Let us now move to the final session of the day, which is entitled Investment Arbitration in Construction, the Past, the Present and the Future. The statistics show that investment treaty arbitration continues to grow in popularity, and cases have spiked during the pandemic where states have made decisions which adversely affect companies. Investment arbitration under bilateral or multilateral investment treaties may be powerful, and sometimes it's overlooked. It's an overlooked tool for a contractor to obtain redress against a state. This panel is going to look at the state of the art based on previous and current experience and at future developments, for example, in relation to the impact of governmental COVID-19 measures on projects. Chairing this final session is our very own Professor Nazzini, and I hope the delegates will permit me to run through his resume once again, because I do believe it's the most impressive resume we've heard today. Professor Renato is a Professor of Law at King's College London and Director of the Centre of Construction Law and Dispute Resolution. An experienced arbitrator and counsel in international arbitration, he has a wide knowledge in the construction, oil and gas, infrastructure, IT and digital sectors. He's duly qualified in England and Italy and understands and navigates the different approaches across common and civil law jurisdictions. He's worked across Europe, Africa, Asia and America as counsel arbitrator, both as president of the tribunal and co-arbitrator and expert witness. He's a member of the ICC Arbitration and ADR Commission in Italy, a member of the ICC Task Force on dealing with corruption issues in international arbitration, and a fellow of the Chartered Institute of Arbitrators. He has published, and this still pains me, 6 books and more than 100 articles and chapters, and is general co-editor or member of the editorial board of 4 leading international journals. He's been visiting professor of the University of Turin, the University of Zurich, and FGV of Sao Paulo, Brazil, as well as senior research fellow at the British Institute of International and Comparative Law, and a professor of international arbitration at the University of Southampton. He holds 2 PhDs, one from the University of London and another from the University of Milan. I'm just going to get my coat, Professor. Over to you.
Thank you, James. But you could have just extracted some highlights rather than go through the whole thing. But thank you very much. And again, great pleasure to be here. I'm very pleased to be joined by an excellent panel this afternoon. In fact, we are 4 practitioners and 2 academics, so we are 6 instead of 4. And I'm very pleased to say that 2 of our speakers are coming from abroad. Krina here on my right-hand side from Stockholm through Madrid, and Paul from Dubai, having already endured a quarantine for the pleasure to be with us tonight. And Philippa and I are coming from around Fetter Lane, so I think that's but let me introduce the speakers first of all. So Philippa Charles, I'll go in the order of in the order of the program. Philippa Charles is partner and head of international arbitration at Stewards. She specializes in complex and high-value cross-border arbitration disputes with more than 20 years experience of proceedings before all major institutions, and particularly for today's purposes, she has great experience in the infrastructure, oil and gas and power sectors. She's a solicitor advocate and also sits as an arbitrator. Now, Paul Stothard at the right-hand side here, the far right-hand side, is a partner at Norton Rose Fulbright Middle East, and he specializes in international arbitration, both commercial arbitration and investor-state disputes. He has worked across a number of jurisdictions, and in particularly in Tokyo as well, in Beijing, in Dubai, as well as in Europe, and practices as counsel and as arbitrator in construction, transport, project, oil and gas, and renewable energy in the renewable energy sectors. And Krina Baltag here, Dr. Krina Baltag on my right-hand side, senior lecturer in international arbitration at Stockholm University, co-director of the International Commercial Arbitration LLM. So my first PhD student was a graduate from Stockholm International Commercial Arbitration Program. And she has extensive practice in international arbitration, again, both commercial and investment arbitration. And she has widely published in investment arbitration some of the leading texts, for example, on the Energy Charter Treaty, on the concept of investor, on the ICSID Convention, and if we want to start the panel, I cannot go through the whole list of publications. And she's also a member of the Stockholm Chamber of Commerce Arbitration Institute Board. Now, we are talking about investment arbitration, and as you know, this is relevant for us. Something perhaps not as widely known to construction practitioners as the niceties of dispute boards and ICC arbitration is relevant to us because a construction project is an investment, or very often can be an investment. We know that, I mean, the case which is always cited is Salini in Morocco, but there were previous cases and many subsequent cases. And because a construction project is almost invariably or very often an investment, it means that the contractor can benefit from the protection that bilateral investment treaties or multilateral investment treaties give to foreign investors vis-à-vis a host state. This provided that the contractor is foreign. Foreign means also the notion of investor. Right? This is Krina here, she's a specialist, but it means not only that the company is incorporated abroad, but also the controlling shareholder can be foreign and so on. So very wide and potentially powerful protection. We have talked today already about COVID-19 related measures, for example. These have had an impact on projects. We have talked about earlier today contractual remedies, but how about treaty remedies against the state? They can be a more effective sometimes avenue for getting redress. But let me start this discussion, however, by really taking a step back and perhaps looking to the future. And by asking Paul, what can we expect of investment arbitration in the future? Because investment arbitration has been very often criticized, and these criticisms come and go by time. Now this is a moment where investment arbitration is not very popular. It's criticized, not well. It is popular and not, depending on the constituency where you are. But really, let me put it another way. It's not getting a very good press. It's very often seen or described in the press as a kind of secretive way by which investors get a lot of money from states, very often emerging economies that are just trying to do the right thing, protecting their own citizens, getting back sovereignty from this very powerful multinational corporation. So is investment arbitration here to stay, or what do you make of this criticism, and what are your predictions for the future?
Well, thank you, Renato. Thank you, first of all, for that very warm introduction. It's very nice to be here in person today. And being 1/6 of a panel of 4 is a rare pleasure. You're certainly right that there has been some criticism of the investor-state disputes system. And much to the surprise of us practitioners, that criticism has seeped into the mainstream. You mentioned some press coverage that this rather obscure area of law has got of late. And I just want to start by reading to you an extract from The Guardian. This was from a couple of years ago. You might have to blink to realise that they are actually talking about investor-state arbitration in this extract, but it says, ISDS is a full frontal assault on sovereignty and democracy, a toxic mechanism that would allow a secretive panel of corporate lawyers to overrule the will of Parliament and destroy our legal protections with rules enforced by panels which have none of the safeguards we expect of our own courts, and hearings held in secret. The judges are corporate lawyers. You might be talking about us, many of whom work for companies of the kind whose cases they hear. Citizens and communities affected by their decisions have no legal standing. And I can tell you from personal experience, if you ever get into an argument on social media with anyone about ISDS, you're in for a bad time. So it's important to remember why the public is engaged with this issue. And fundamentally, it's because of this. ISDS can and does often involve disputes in which very large sums of public money are in issue. And there can be issues of genuine public interest. For instance, a state's fiscal policy, developmental issues. I've personally been involved in a dispute involving the water supplies to a capital city, which gained an enormous amount of public interest. And the public also, they rarely have their interests, rarely have their interests drawn to the kind of investor-state disputes that will probably concern us, involving construction projects, concerning projects involving different jurisdictions. They're more, the kind of disputes which get public interest tend to be like the Philip Morris dispute, the famous tobacco dispute, in which clever practitioners push the very edges of what we understand by investor-state arbitration to argue, for instance, that that removing images of tobacco off packaging could be some kind of expropriation. Understandably, that has created a backlash, and we see that now. So what we have seen is some states start to withdraw from participation in the ISDS system. South Africa, for instance, has withdrawn entirely. There's been a sustained push from the EU to replace their investment treaties with, their reliance on investor-state dispute mechanisms with some kind of a multilateral investment court. If I've got time, I'll give you my views on whether that's a realistic proposal. But looking at some of these criticisms, the reality is there are some merits to these criticisms. They do have a kernel of truth. ISDS was often transplanted onto ill-fitting commercial arbitration systems in the past, where there was a lack of transparency, where the system had been designed more for commercial arbitration as opposed to investor-state disputes, where there are these public interest issues. But the system has reformed itself to some extent from within. Untitled, for instance, has changed its rules to introduce entire suite of tailored provisions dealing only with investor-state disputes, which give parties, which give the public the right to extensive information about the proceedings and so forth. So it's not true, I think, these days that ISDS conspicuously lacks transparency. The other criticisms still continue to bite. It is a slow and cumbersome system across various different forms of ISDS. I believe that the average ICSID case continues to take, I think, 4 years to reach a decision on the merits, and another 2 years if the annulment procedure is invoked. And, you know, frankly, notwithstanding the fact that these cases often involve huge sums of money, very complex issues, that's just too long. And, you know, things can be done. And again, the system is trying to reform itself from within by adopting, for instance, summary procedures to dispose of manifestly unmeritorious claims. And then there's the issue with the underlying treaties themselves. The first generation, second generation of investment treaties contained provisions which were manifestly open to multiple interpretations, particularly in the hands of these dreaded corporate lawyers who were not public international law specialists. And this is something that the states themselves have been seeking to address by guidance on interpretation, sometimes panels who will provide the interpretive analysis for the parties of particular provisions, and sometimes just greater clarity in the scope of the substantive rights under the treaties. So just one thing I would say, just in conclusion, because I know we don't have very long. The idea of replacing the existing ISDS system with a multilateral investment court is interesting. My concerns, very briefly, are twofold. First, it seems to do away with some fundamental principles of party autonomy that we have in the arbitration system that we hold dear. And that's particularly in favour of the states, who will ultimately appoint all of the judges and be largely in control of the process. But more fundamentally, I think even than that, I find it difficult to see us replicating a system where we have, as with the New York Convention and the Washington Convention, 160 odd signatory member states, where you can carry your award around the world. If we do find something similar with a multilateral court where you can enforce judgments internationally that widely, I think it's going to take an enormously long time and a lot of international cooperation. So I think these two systems are going to be living in parallel with one another for the foreseeable future.
Thank you, Paul. And what I take from that is, and I tend to agree with you, that investment arbitration is here to stay. Hence, we have really to face a number of challenges, I think, going forward. And one of them is that states are more and more committed to greener policies, greener regulation to respond also to the climate change problem and to other issues. So the question to you, Philippa, if I may, do you see that as potentially generating disputes or claims, and what is the role that investment protection and investment arbitration may play, and are there perhaps lessons we can learn from the past, from the renewable energy disputes and the Energy Charter Treaty, for example?
Thank you, Renato, and good afternoon, everyone. I'm very pleased to be here with you. I think, what Paul has sketched out is a process of transition in which both investors and, I think to a much greater extent, states have become much more savvy, much more understanding of the burdens that are placed on them by their international treaty commitments. And in that context, I had a look at the UN Climate Change Conference COP26, which is happening in a few weeks' time now in Glasgow. And the aims of the conference, or the goals of the conference, are expressed quite neatly as 4 main aims. First of all, to secure global net zero by mid-century, in respect of which they're saying that they want countries to come forward with ambitious emissions reductions targets and plans to deliver on those targets. Adaptation to protect communities and natural habitats. So they're talking expressly about ways in which ecosystems can be protected and that defences and infrastructure can be modified best to achieve those goals. And the mobilisation of finance to make all of this happen, including a specific commitment, or the seeking of a specific commitment for more private money to come into the process of meeting these climate change goals. And that ultimately is going to trickle down to contractors and parties working in big infrastructure and big construction projects, because without a doubt there will be consequences for those participants as a result of the commitments entered into by state governments at this level, at the level of the UN intergovernmental discussion. So look, the commitments are very broad brush, very difficult to assess from those global broad aims how the implementation is going to work or what's going to be expected. But the imperative is clearly there. And so it struck me as instructive to look at the last phase of effort that was put into greener, in this case, energy, and the solar power projects which were subsidised or incentivised by state governments in the early 2000s, with a view to getting private money effectively to bear the burden of the high build cost, on the basis that they would then subsequently recoup that investment by way of tariff enhancements or commitments to a sort of stable regime in which their initial investment would be well remunerated by the end of the project. And what then happened was that after the global financial crisis, these countries, particularly Spain, Italy and the Czech Republic, either withdrew or phased back the benefit to contractors or to investors of having put in the effort to put in these solar projects in the first place. And it's generated a raft of claims. I think there were 30 as of this time last year against these states on the basis that the effect of that change in direction by government had been to rob them of the economic benefit of their project. It amounted to an expropriation, or more carefully and more interestingly, it amounted to a breach of the fair and equitable treatment obligation on those state governments vis-a-vis those entities as investors. Now, the fair and equitable treatment standard obviously varies between bilateral investment treaties, the multilateral investment treaty, including the Energy Charter Treaty, under which most of these claims have been brought. But broadly, the example that we can learn, or the lessons we can learn from this, are that states can be held liable for defeating legitimate commercial interests of investors in the outcome of an investment process like that. However, what tribunals have gone on to say is that states are not required to preserve in aspic the regulatory position at the time of entry into these arrangements. So whilst investors have a legitimate interest in a good outcome from the project, they're not entitled to insist that governments can no longer change the law or revisit the merits of a scheme such as a feed-in tariff exemption or a feed-in tariff enhancement. And so the lessons learned, I think, for the future and in terms of implementation of COP26 is that, as Paul says, states are going to be much more circumspect about the kinds of commitments they make in the future in relation to what is obviously going to be a fluid area of development. They will, however, have to balance that with the need to encourage private money into the process. If the UN is recognising that states alone are not going to be able to achieve the COP26 targets, there's going to have to be a balance between the two. And I think, future regulatory change might give rise to a claim if the effect is to damage the legitimate expectations, as I've said, and there are some very big money awards that have been made to solar investors. But the fair and equitable treatment standard requires governments to act transparently and in ways which meet a procedural standard. And I think if governments do that, if governments are clever about the way in which they introduce these changes, then investors or contractors may be stuck with the fact that governments are able to act in this way. And so contractors, it seems to me, would be very well advised to look at contractual mitigations as far as possible, in addition to the potential to bring a long, drawn out and expensive arbitration process under ISDS. And that really, it would seem to me that the contractual mechanism is probably preferable in most cases to going down that road, given the uncertainty as to whether or not governmental change would actually amount to a viable claim in the future.
Thank you very much, Philippa, for this very insightful overview, and also look at the future. And you ended by saying, well, perhaps in relation to this type of dispute that you were discussing, perhaps the contractual mechanism is preferable to the treaty mechanism. So, I mean, the question in a sense I would like to ask Karina is, well, what is then the difference between treaty claims and contractual claims, and what should an investor consider and look at when deciding which avenue to pursue?
Well, thank you very much, and thank you, the organizers, for the opportunity to be here in person with these distinguished colleagues as well, and with the audience also online. Most of the infrastructure projects, as we know, although they're in the investment arena, they will start as contractual arrangements between the parties. So one question would go what we have now, and the second question would go to the future of ISDS and whether parties would prefer, as you said, to stay in this contractual arrangement. There are certainly advantages to be at international level. When you have a contract entered into for the construction of a highway, you probably deal with the highway authority in a particular state, but that highway authority or conduct of that authority may amount to a conduct of the state itself. So for an investor, it might be in a better position to go straight to the state and demand that any damage that is caused, any prejudice, any wrongdoing will be claimed from the state. States, they pay. That's the most important thing. But of course, what is important to note also that a contract will not guarantee this access to the international level. As we say, investors will try to elevate these contractual claims to the international level. And going to the first question, in the past, we've seen different approaches on how pure contractual claims were upheld by arbitral tribunals, by investment tribunals in this international setting, but also how contract claims were seen as treaty claims for various reasons. So I will not go into much detail, but there are certain mechanisms under the treaties with very nice names assigned, like the fair and equitable treatment. We have umbrella clauses. And the mechanism of the umbrella clauses would do exactly this. They will cover, for the purpose of an investment arbitration, they will cover any contractual arrangements between the parties. And if you have the example of that highway project with a highway authority, then an investor can go and pursue the state. And that contractual claim, because it's covered by this umbrella clause, because the treaty covers any relations between the parties, will have its way in this international arena. There are other treaties that would adopt a more flexible approach as to what type of disputes are covered. So in that dispute resolution clause at the end of the treaty, it might be a general reference to any disputes between the parties, between the investor and the state. And there are several tribunals that held that that would cover contractual disputes as well, as long as it involves an investor and the contracting state. And of course, there are treaties that cover any investment agreements. And I think this goes a lot to the future, investment authorizations and investment agreements. So there's a lot of room to hold pure contractual claims and to look at them at international level by an investment arbitration tribunal. But more often what we see is these treaty claims, contractual claims that are in fact treaty claims. And the past years gave us, mostly as academic, a great opportunity to look into the cases involving the Central Asian states. A lot of infrastructure projects. One example would be the cases against Turkmenistan, where in essence there were several contracts, several 60, 30, quite numerous contracts between the investor and the host state. Most of the contracts with public authorities or with different entities controlled by the state, where the tribunal had to decide whether an alleged conduct of the state could amount to this treaty breach that would entitle an investor to claim against the state. And we referenced the Salini. There are other cases before these cases, in particular Binder against Pakistan, which is one of the landmark cases. The tribunals in this Turkmenistan cases said, well, a claim can qualify as both contractual claim and a treaty claim. And this doesn't mean that the investor cannot choose between a contractual avenue that might be under the contract. In this particular cases, each contract had a governing law, usually the Turkmenistan law, for example, and also an arbitration or a litigation dispute resolution clause. So, for example, some had ICC arbitration. And the tribunal said the investor can choose. You can go to arbitration or you can go to investment arbitration. But to go to investment arbitration, you need a bit more than the pure contract. You need to engage the state responsibility at international level. But the conclusion on this is that you can, with a contract as an investor, having an investment, I think that's also important to highlight that the first requirement is to have an investment. And sometimes one contract may not qualify as an investment, but you may have a suite of contracts, or you may have an investment in the form of a subsidiary or a company open in the host state. Then you can resort to international arena, as I said. For the future, the second question, this goes exactly to the previous discussion. probably some of the major companies will prefer to have a contractual arrangement. But that contractual arrangement, of course, likely, as I would be an investor, I would not choose the local courts. I'll probably resort to a commercial arbitration venue, which means that for small investors, for small companies without the bargaining power, it will be difficult to resort on this contractual arrangements. But I think we can discuss more about this.
Absolutely. I am aware that we are 4 minutes from 5 o'clock, but I am chairing. I am the director of the center, and I'm abusing my position, so we'll have a little bit more time. So, yeah. So
we are keeping people from there.
No, just a few extra minutes, of course. Now, but then quickly, clearly there are, pros and cons, in going for investment arbitration, treaty protection or not, or pursuing only a contractual avenue. But certainly, I think what I take from your views, and I would tend to agree, it's a nice to have thing, isn't it? For a contractor and for an investor. So anything one should think about when making the investment. So before entering into the construction contract, the JV, or whatever it is, in terms of maximizing the treaty protection that then you may have if a problem does arise. Paul?
Yeah, sure. So, I mean, imagine your client is standing on the brink of making an investment in a mega project in my part of the world, where these mega projects are announced on Monday and then cancelled on Friday. And it may be that your client is fortunate enough to hail from a jurisdiction that already has a investment treaty between, with that particular Middle Eastern state. But if that's not the case, or if the level of protection afforded by that treaty is not optimal, your client might like to consider whether there is some structuring, investment structuring, which is a polite way of saying treaty shopping, that's the pejorative term, that could be adopted at the investment.
The Guardian view, isn't it? It's
the Guardian view, yes, yeah. So that could be structured at the early stage. Now, this is a concept that would be familiar to our tax colleagues who, will incorporate holding companies in jurisdictions where, there are tax efficiencies, and it is exactly the same for obtaining the benefits of investment treaties. The relevant considerations for this kind of thing are likely to be where are these optimal protections likely to be found? Do the treaties in these jurisdictions is your client eligible to have investment protection under their terms? So do they qualify as an investor? And in this case, most treaties will broadly define investors. So it is simply a question of incorporating a holding company and structuring the investment through that jurisdiction, but it's not always the case. It can be that some treaties require some sort of controlling mind or real economic activity to be with the investor. So that's something that has to be checked at the due diligence stage. You have to check to see whether the type of investment is covered by the treaty in question. As you've heard, contractual rights, the kind of projects that we're concerned with here will almost invariably be covered by most treaties. And then it's a question of checking out to see whether, the suite of investment protections are adequate. And, one point we make repeatedly is that investment treaties contain similar provisions, but they're not always the same, and some of them, particularly the older ones, can actually be. Some don't even give recourse to investment arbitration at all. There's some Chinese ones of old I know from my time out there that simply provide the tribunal with the right to value an expropriation. Obviously, the more modern ones are more comprehensive. I should just say treaty shopping can be a controversial concept. There is a movement towards we've seen from some of the proposed revisions of some of the rules at the moment of declaring the structure during the proceedings to see whether any form of abuse has taken place in terms of the investor bringing the claim. Your question was aimed at sort of structuring, but I think it's relevant to mention what happens in the not uncommon situation where an investor seeks to restructure either when the investment is on foot or when a dispute has arisen. And I'll just very quickly mention a couple of cases to demonstrate how this has been dealt with by tribunals. The first is the Aguas del Tunari and Bolivia matter, which concerned a water concession. And here the investor restructured. So the holding company went from BVI to Netherlands. Netherlands, for some reason, seems to be the leading jurisdiction for these, with lots of BITs. Yeah. The state argued in that case, having nationalised the investment, the water concession, that this restructuring having happened only a few weeks before the nationalisation, it was an abuse, but there was no evidence that the investor knew that this was coming, and the tribunal wasn't convinced that there was any kind of abuse of rights there, which could defeat the ability of the investor to bring the claim. But contrast that, please, with Phoenix Action and Czech Republic, where here you had, I think it's probably a textbook abuse situation where you had a domestic investor, so not even a foreign investor, a Czech investor with a Czech investment. And upon learning that there was going to be a dispute coming along the way, inserted an Israeli entity as a holding company and then claimed to benefit under the BIT between Israel and the Czech Republic. And unsurprisingly, that was deemed to be impermissible, and that claim failed.
Thanks very much, Paul. And then very quickly, Philippa, do you have any views of your own on investment structure or restructuring? And
yeah, I mean, obviously the two main things are the sooner the better. You know, clearly, it's a day one consideration if you're going into a potentially difficult jurisdiction to consider your options on structuring. And the other thing I would say, to strike perhaps a slightly parochial note at the end of this day of international considerations, is that in a post-Brexit world, there is, of course, the possibility that the strenuous efforts being made by the EU to move EU member states away from the ISDS system might, in some respects, be countermanded by an independent UK judiciary continuing to uphold the sorts of rights that have historically been available to investors under the BIT system. And so that may form part of a structuring discussion to work out where those disputes will ultimately now be heard and where any challenges will be heard. So that may be a further consideration in structuring discussions in the future. Yeah,
which may well mean that London becomes an even more attractive forum for
you identify the benefit of Brexit.
Yeah,
oh
well,
God, did I?
Anti-suit injunctions and seat for investment arbitration.
Wholly unintentional.
Yeah, absolutely. So really, the very last question, very quickly, starting with CRINA, because this was an issue that surfaced many times during the day, and so we conclude on this note, which is, well, how about COVID-19 related measures? How do you see CRINA potential disputes there in the role of investment arbitration? I know you can't do it in 60 seconds, but please try.
Well, I think it's important to note that in at least in commercial disputes, we see already disputes related to COVID-19. In investment cases, as we know, this will take a while, in particular because treaties have a cooling off period of 3 or 6 months that has to be observed. So probably next year or so. The treaties do offer mechanisms. The fair and equitable treatment, Philippa was mentioning earlier, legitimate expectations, transparency. We know that investment agencies, at least in the COVID times, were more involved in informing investors rather than dealing actively with the protection of investments and promotion. So there will be probably fair and equitable treatment relied on quite extensively, expropriation measures, of course, maybe some sort of discrimination between national investors and foreign investors. We have the FDI screening procedures now, very much implemented during COVID times. So that's something that has to be observed. And of course, an allegation, perhaps to some extent, that the COVID was just an excuse of implementing measures against investors. Now, what the states have is the right to regulate, what Philippa was mentioning earlier. And it's not new. Philip Morris case is leading on this subject. The states have the right to regulate for health and public interest. Now, the question is if the measures taken by the state as part of this right to regulate were above all proportionate. Some situations will probably reveal that were other measures more reasonable, more appropriate for the specific case to be adopted by the states. So I think on both sides there will be argument going back and forth. There is substance on both sides, I would say. The state has the right to regulate and should have the right to regulate, but at the same time it has to be done, as mentioned before, in a balanced manner, allowing investors to protect their investments and in the future to continue to attract investments.
So that's the famous, I think my view on that is all depends on the particular circumstances of the case. But just a very, very quick final observation of Paul and Philippa on COVID-19 related measures, if any.
I suppose my observation was that, like many of my colleagues, I was filling volumes in journals about how we were going to be flooded with the claims, and I'm yet to see any. I mean, I think maybe it takes a while for them to trickle down, and certainly I think the using it as a pretext to, for instance, terminate contracts that you wanted to terminate anyway on the grounds of force majeure, I'm sure that has legs. And we will see some of that. But I've been quite surprised by how little disputes. We are very busy from a disputes perspective. Very few that touch directly on COVID-19.
Yeah, I think that's my experience too, that there are very few active disputes yet arising directly out of COVID-19. I think in the international context, one thing that I think we will see will be attempts by investors to play states off against each other in terms of regulation affecting particular industry sectors, who's released first, you know, the hospitality sectors, cruise ships, airlines, travel, you know, those industries which have been hardest hit will, I think, end up trying to divide and conquer by referring to notionally successful or notionally less oppressive regimes as a way of demonstrating a breach of fair and equitable treatment. But, you know, in a crisis situation, governments have to do the best with the information that's available to them at the time. And I suspect we may end up in a sort of Argentina type situation where some of the measures are deemed to be reasonable and proportionate in the circumstances of a crisis and others are not. And, you know, it's all got a long tail. So for those of us who are, you know, litigators by trade, I suspect COVID-19 will still be part of our lexicon for quite some time.
Like the global financial crisis.
Yeah.
Exactly. I agree with that. Now we are on time because I think that clock, I'm told, is 10 minutes fast.
You're on time for an Italian, Renato,
Yeah.
which is different to being on time. Just very quickly, there are 3 questions that I have from the online delegation, and if I could fire them and ask for one answer from one of you in a very short space of time. The first question is this: how useful are sovereign guarantees as a protection against the default of state-owned entities with no assets other than their equity contribution in the project assets?
Oh.
I'm not sure I even understood the question. Sorry, I'm putting my hand up for that.
Well, that's as I understand it, because I think Italy, for example, has this system of state guarantees. I mean, it's a state or a state entity, which is obviously different from the entity or the contract or whoever the employer is in a particular project, does give a guarantee against the default of the the host state entity. Well, they're only as effective, I think, as the trust that you have in that particular state and in state guarantee and any possible enforcement mechanism. And that would be my my advice. So, I mean, look at what, how much you can trust them, what's their track record, and if everything goes wrong, what's your remedy? And so you are back to square one, really. I mean, investment arbitration or some other contract.
Is the question going to be, is holding the guarantee an investment for the purpose of a investment treaty, in which case you get into the debate about the Salini test being met and all that kind of thing, I suppose.
Exactly.
Thank you. The next question, what governing law binds or holds sway in an investor-state arbitration process, particularly when there was no prior arbitration agreement in the initial contract? The clear case in reference is between SPDC and the Nigerian government, where the arbitration dispute has been registered with the ICSID.
It's public information.
Well, the obviously depends. In this example, we have the ICSID convention. I assume it's not an ICSID facility, but an ICSID convention. The ICSID convention has a governing law, a provision in the convention that the tribunal will have to observe. Of course, it is for the parties to submit their position. If you remember the cases, the intra-EU cases, where the European Commission has intervened as an amicus curiae and made the case in support for the EU member state that EU law should be held by the tribunal and interpreted properly, one would add. So that's very, and the BITs as well, the treaties might have a similar law. So that is the question of the interplay between the two systems, the treaty and if you're under the ICSID convention. And
finally then, in the panel's view, do or should international investment treaties and ISDS encourage construction companies and lenders such as banks and ECAs to be involved in large-scale construction and infrastructure projects in developing countries?
Well, I mean, that's the whole point of the investor-state mechanism as part of the overall FDI efforts made by developing countries to attract big companies and big banks into these kinds of arrangements so that they have some sense of there being an independent means of protection for that investment in the event that it goes south. So, that's the whole purpose of what it's there for. And if it's not working, then, the Monbios of this world, I'm assuming it was Monbiot.
It was actually,
yeah,
yes.
So I got into a Twitter row with him some years ago. He still doesn't like me. The Monbios of this world will continue to chip away at the public perception of the good that it does. And actually, it really does do good when it's used properly. So that's what we have to have in mind when we're looking at reform efforts, is not to throw the baby out with the bathwater.
All right. Well, before I hand over to Professor Nazzini to close the conference, please show your appreciation for Professor Nazzini, Philippa, Paul, and Karina. Professor.
Thank you very much, James. It's not going to be a long closing. We do have drinks for those who are here in the room upstairs on the 8th floor and on the terrace. I mean, yesterday the weather was a bit strange, but today wonderful September evening. So the closing is just to thank the speakers, first of all, here on my panel, to thank James Pickavant for being really a driving force behind this conference, last year's conference, for chairing it from beginning to an end. A great relief for me. Thank all the people online, all the attendees online, particularly those current and former students, and everybody here who was brave enough to attend in person. And finally, and really last but not least, I'd like to thank all the teams at King's who made this possible. This is the first in-person event, hybrid event, I should say, which has its own challenges, running it online and in person. This is the first at King's since March 2020. Teams at King's at the center, Susan Hart, the audiovisual team who are here today, and the events team led by Martha Clark here have worked very hard. I mean, everything seemed very easy today, but there is a lot of work behind the scenes that has gone on to put up this event. So a great, really very heartfelt thanks to all my colleagues at King's who helped us and made this possible. So thank you. And now we close the online conference. And for us, we'll see each other upstairs for drinks. Thank you very much.